All right. Well, welcome everyone, and thank you to the Decalogue Society for having me. My name is Ross Seckler, and today we're going to walk through some of the most consequential legal developments in election law that this country has seen in over a generation. And I want to be clear and upfront, this is not designed to be a partisan presentation. You may understand where I'm coming from on some of this, but this is a constitutional statutory analysis of what actually is happening right now in courts and administrative agencies. And in the Illinois context, it's affecting county clerks and elected officials and candidates, no matter what letter is next to their name on the ballot or off the ballot. Whether you practice in election law or not, I promise you these issues matter to your practice and to your clients. Election law sits at this intersection of constitutional structure, administrative law, privacy concerns, federalism, and civil rights. And those rules are being tested right now, and those shape the legal landscape for years to come. So even if you've never filed a ballot challenge or have never done any campaign finance or anything else in your career, what we discussed today, I hope will give you some framework and understanding for these structural battles playing out in our country and potentially coming before your desk in some other way. Additionally, this is fast moving and changing. I had to update this presentation literally today because there was a court ruling this morning in Alabama that we'll talk about. Very quickly about me, I am currently the president of the Chicago Bar Association Election Law Committee. I have served for a few years and had previously served in that role before being asked back. And then I handle a lot of local government law, but at the same time focus on election law representing candidates, parties, committees, up and down the ballot from most local school boards or other local districts to up to, we represent presidential candidates in Illinois, U.S. Senate, everything in between. Have handled many types of election-related litigation, whether it's done redistricting on the municipal level, which follows federal standards, as well as ballot challenges, recounts, discovery, all that kind of thing. So I've seen it all. I've handled it all, and many of these things that we're going to talk about are very concerning. I've provided this bit of a roadmap, and with seven general sections we're going to move through today, moving from constitutional foundations, kind of setting that level in federal and how these federal state conflicts are playing out. And then I'm going to continue laying some of the groundwork, that constitutional allocation of election authority and what the statutes actually say. And then we move into executive action and federal voter data demands, covering some executive orders and also the proposed SAVE Act, or the revised one, SAVE Act, that is currently being debated in Congress. Then I'll turn to the Bost and Watson case and talk about USPS, this mail ballot issues and changes that we see coming. And then because that wasn't enough, recently the Supreme Court decided to upend all redistricting law, and we'll talk about the Louisiana versus Callis redistricting case and its aftermath. Before I want to dive in, I want to give you the lens in which we're going to view everything today. Essentially, that state authority, in the general thesis, state authority over elections is being squeezed from two directions simultaneously. From one side, the executive branch is asserting control the Constitution never granted, federal Constitution, and from the other side, the U.S. Supreme Court is stripping away federal protections that have safeguarded voters for decades, and that dual pressure is the thread connecting every section we're going to talk about. Basically, the objectives for today is to give you that framework and understanding. I know some of these are big topics and you hear about more in the news, but it really is to understand this pressure and what actually is happening, because a lot of news organizations don't get it fully correct, right? This is complicated stuff. It's fast moving. There are nuances to all of it. And so to understand, and as lawyers, it's our job to really be able to distill this all down and explain it to people that the first three that we're going to talk about things are about constitutional allocation, statutory framework, and ballot deadlines. Those establish legal foundations that the executive branch is really testing. And then the remaining objectives address those practical flashpoint areas, the postal changes, federal enforcement, threatened federal enforcement at the polls, and then the Supreme Court's redistricting earthquake. And the broader implications that this all has on general federalism. Each section kind of builds on the next one, and by the end, I want to try to weave this interconnected ball that we could, you can see how this all plays out together. Again, my core thesis here is that we're in really an unprecedented era for American elections, and the central tension running through everything we'll discuss today, and what I want you to hold this framing in your mind for the next hour, that state authority over elections is being attacked from those two directions that I talked about. The one from the current federal administration asserting executive control over elections, and the DOJ, for example, demanding complete unredacted voter databases from every state. Federal agencies claiming some supervisory authority over that no other statute actually gives them. And again, the executive branch trying to insert itself where it never has been before. And on the other side, the Supreme Court systemically removing federal protections that have been in place for decades. That the callous decision in redistricting, the willingness to get involved in cases so close to an election that counters certain other principles that we've seen. The result is states are being squeezed from both directions, from the executive and from courts. And while the constitutional framework is clear that states administer elections, Congress may regulate them, and the president has no independent role. But that framework is being tested like never before, and that's why every lawyer in this room, whether you practice election or not, election law or not, should take notice. And someone has to figure this out, and it falls to us as lawyers to do. So to start with constitutional foundation, because really everything else flows from it. If you take one thing away from this entire section, it should be the allocation of election authority is not ambiguous. The Constitution is ambiguous in certain ways, but it's actually the Constitution is actually very clear here about who does what, and that clarity makes recent executive branch behavior so legally significant. And I want you to think it's the elections clause. Think of this section as building your analytical toolkit, basically. Before we can evaluate whether any particular federal action is lawful or not, we need to know what the baseline constitutional structure is, right? And we do that by when we do that analysis carefully, we find that the executive branch has been asserting authority that does not exist in the text of the document, and that's not a political statement. It's just a fact. The Supreme Court has recognized the fundamental principle long ago, and courts have consistently reaffirmed it, that elections are matters of state administration subject to congressional regulation, not subject to any executive direction. And keep that principle anchored in mind and anchored as we move on. So we have the elections clause, Article 1, Section 4 is where it all begins. And I gave the entire actual text. It's later in the presentation, I actually provide the actual text. But the clause states that gives the authority to prescribe the times, place, and manners of holding elections for senators and representatives. And Congress can alter those regulations, but may not abolish them entirely. Notice what is missing, though, is any mention of the president. The executive is simply not part of the constitutional equation. That structural omission is not an accident. The framers were quite deliberate about separating election administration from executive power, precisely because they understood the danger of allowing the branch that benefits from elections to also control them, and having a singular authority to do that. When we look at what the current administration is doing, demanding voter databases, issuing executive orders purporting to change election procedures, threatening to deploy federal personnel to polling places, that the threshold constitutional question is always, where is the congressional authorization? We have Youngstown Sheehan 2 versus Sawyer case. It talks about executive power as at its lowest ebb when it conflicts with congressional allocation of authority. And in the election context, Congress has allocated authority to the states, not the president, and that is the doctrinal foundation for every legal challenge we will actually discuss today. Again, Article 2 of the Constitution grants the president the executive power and requires faithful execution of the law. That is, as far as elections are concerned, that is it as far as elections are concerned. There's nothing actually mentioned in Article 2. There's no Article 2 power to direct state election officials, override state ballot deadlines, seize voter databases, or deploy federal forces to supervise voting. When we see the executive branch doing these things, the question is always the same. Again, where is the statutory authority? Where's the constitutional authority? Because without a specific congressional grant of power, executive action in the election space is constitutionally unauthorized. This matters enormously right now because the administration is making aggressive claims about inherent executive authority to ensure election integrity. But that's a constitutional matter and not an executive function. It's also a state function subject to congressional regulation. And the courts have addressed these claims so far. The courts addressing these claims so far have been largely receptive to that argument. That the principle from steel seizure is doing real work here. Even the most compelling policy rationale cannot substitute for missing constitutional or statutory authority. We'll see how that continues to play out. And now we'll move on and kind of mix in some of the federal statutory framework as well. And so, again, the Constitution and the Elections Clause, I put it in here because it is worth reading the actual plain text, and it explicitly divides the authority between states and Congress. President is not part of that equation, and the omission is constitutionally significant. The provision gives states primary authority to prescribe the time, place, and manner of federal elections, and Congress retains overriding regulatory power. What it does not do is give the executive branch any independent role. The structural design reflects a deliberate founding era choice to keep elections out of presidential control, and really there's that two-party framework between state has the default authority and Congress has override. Nothing to do with the executive, and that's the baseline that we start with. So then moving, I guess most significantly more recently, the Help America Vote Act. This was in 2002 was Congress's response to the 2000 Florida election crisis, and established minimal federal standards for voting systems, provisional ballots, and voter registration databases. But not the design sets a floor and then leaves states to build above it. That's cooperative federalism. That's what we've seen in the past. It's not a federal takeover of elections or any attempt to even come close to it. For our purposes today, the most important provision is Section 303, which requires states to implement a single uniform official centralized interactive computer statewide voter registration list. That requirement has become the hook the DOJ is currently trying to use to claim it has access rights to all the lists and all of the data. But the HAVA's database requirement was designed to improve election administration, not create a federal inspection regime. The statute contains no provision authorizing the federal government to compel disclosure of the list. It doesn't authorize the Election Assistance Commission, which is created by HAVA, and an independent agency. HAVA does authorize the Election Assistance Commission, an independent agency, not the DOJ, to provide guidance and to conduct studies, but it does not allow the DOJ or any other governmental agency to just demand access. The limited role of the EAC is a far cry from broad supervisory authority that current administration is now asserting. And if you see HAVA cited as authority for federal voter data demands, that is your signal that the legal theory is overextended. Okay. So HAVAs does have identification requirements. It's set out in section 303B, and they're deliberately narrow and specific. And for the first time, especially voters who registered to vote by mail, required presentation of a current photo ID, a copy of a utility bill or bank statement, or the last 4 digits of a social security number. That is the full scope of what Congress chose to mandate federally in terms of voter identification. This carefully calibrated provision, not a blank check for the executive to impose additional requirements. And the structural takeaway here is essential. Congress made a deliberate choice to use cooperative federalism rather than federal command and control. States get flexibility. The federal government gets a limited oversight through the EAC, and the Congress set the floor. It did not make a mandatory requirement that you have to have every voter register have a photo ID, for example. When the executive branch, which now is claims authority beyond those specific grants, is not just exceeding HAVA's terms, it's violating cooperative federalism design that Congress chose. And that design is judicially enforceable. Courts have already applied that in major questions doctrine and anti-commandeering principles. Those cases are New York versus the United States. It's a 1992 case, and Prince versus the United States, which is a 1997 case. And those give subsequent courts and lawyers tools to enforce the act. Before HAVA, we had the National Voter Registration Act of 1993, which is known as the Motor Voter Act. That's the statute sitting at the center of a lot of the DOJ voter data litigation as well. And I want to walk you through some of those key provisions because this is where the legal battle is actually most active. The NVRA imposed 2 major categories of obligations. First, it requires states to provide voter registration opportunities at DMV offices and public assistance agencies. So expanding access required states to allow people to vote or register to vote at those points of contact. Second, it requires states to conduct list maintenance, removing voters who died, moved, or become ineligible. The DOJ is using that and claiming the NVRA's list maintenance requirements combined with the provision in the Civil Rights Act allowing inspection of records relating to federal election administration authorizes the bulk extraction of complete unredacted voter files, including driver's license numbers, social security numbers, and full voting histories. But if you read the statute, Section 8I of the NVRA requires states to make records concerning the implementation of voter registration programs available for public inspection. That provision was designed to enable public accountability, allowing organizations to verify that states were complying with registration requirements. It's not designed to give the federal executive branch a right to download entire state databases. The phrase reasonable efforts in Section 8A governs what states must do for that list maintenance. Again, like we just talked about with HAVA, this is a floor, it's not a ceiling. It certainly doesn't imply a federal right to audit the results by inspecting raw data. The gap between what the statute actually authorized and what the DOJ continues to claim is frankly erroneous. This is where we get federalism tension, and this is where the rubber meets the road, so to speak. And I want to be very precise about the legal arguments here because it's matters for advising people about what's actually going on. The NVRA's public inspection provision, Section 8I1, was designed explicitly to enable citizen oversight of voter registration programs. That legislative history is clear. The provision was modeled on analogous transparency provisions in civil rights statutes intended to allow advocacy organizations and individual voters to verify that the registration processes were being conducted fairly. It is not a federal inspection authority. It was a public accountability mechanism. And what the DOJ is doing now is taking that provision designed to empower citizens and is reinterpreting it as a grant of executive supervisory authority over state election databases. And that interpretive move is not supported by the text, the structure, or the legislative history of the statute. And importantly, even if you accept the DOJ's reading of the NVRA, it would still run into anti-commandeering commandeering doctrine under the Prince and the New York versus United States cases I mentioned before. The federal government cannot conscript state officers to implement federal programs or compel states to surrender their administrative databases. The states that refuse to comply seem to be on solid legal ground, and the courts that have reviewed early motions in this type of litigations have been skeptical of the DOJ's theory, and we shall see. But now we'll move on to executive branch direct engagement with state election infrastructure. I'm going to cover two major developments: the federal government's renewed demands for voter data, and what that actually means and what this is, from the 2017 Kobach Commission through the current DOJ and DHS request, and the legislative effort to reshape voter registration requirements through executive orders and the SAVE Act. What connects these developments as a common theme it's an assertion of federal authority over traditionally state-controlled election functions, accomplished through executive action rather than a normal legislative process, less the SAVE Act, but that has stalled, as we'll talk about. Whether it's demanding voter rolls under claimed authority from HAVA or NVRA, or conditioning federal registration on documentary citizenship proof, the pattern is the same: an expansion of federal power at the expense of state sovereignty over election administration. So let's look at what these numbers are and what's going on. Because of the scale of this litigation is actually precedented. The DOJ has filed suit against 30 states plus the District of Columbia for refusing to hand over complete unredacted voter files. To put that in perspective, there's more election-related litigation than the federal government initiated in the previous 2 decades combined. These are not routine public records requests. The DOJ is demanding driver's license numbers, partial social security numbers, full birthdays, and complete voting histories for every registered voter in each state, including, for example, in Illinois, which party ballot you took. The privacy implications alone are staggering. That's essentially a demand for a comprehensive federal dossier on every American who has ever registered to vote. Most states have refused, and for good legal reason. Many state constitutions and statutes affirmatively prohibit this disclosure of certain voter data fields, particularly social security numbers, and are protected by state law in almost every jurisdiction. So even if the DOJ's federal statutory theory were correct, the states now face a genuine conflict between the federal demands and state law privacy protections. That conflict itself is a federalism issue, is one that courts are only beginning to sort out. Illinois, for what it's worth, is among the states that have pushed back, and the Illinois State Board of Elections response in its litigation is worth reading if you have any contact or advice to election administration officials or just generally interested in this further. We'll walk through the DOJ's legal theory here again more because to understand its weaknesses, and it's essential for any lawyer advising or talking about this issue. Basically, the DOJ is stitching together 2 statutory provisions: the NVRA's list requirement under Section 8 and the records inspection provisions of Section 8I, combined with the provision of the Civil Rights Act of 1960 that allows the Attorney General to inspect records related to federal elections. Neither provision, read in context, authorizes wholesale extraction of unredacted voter databases. The Civil Rights Act of 1960 provision was enacted to address specific civil rights violations, the systemic destruction of voter registration records in southern states that were being used to suppress Black voter registration. It was not a general grant of federal access to all voter registration data nationwide. And the NVRA's inspection provision, as I know that was public accountability mechanism, not an executive audit authority, uh, in federal database, creation authority. So when we string these together and claim they, and see the claim that they authorize bulk database downloads from all 50 states, we see that there are major questions and arguments without invoking the major questions doctrine. And courts applying, it's West Virginia versus the EPA and Biden versus Nebraska, we hope are going to demand clear congressional authorization for a claim of this magnitude. That is precisely the kind of executive overreach that defines one side of the dual pressure of the state election authority that I described from the outset. And this litigation is going to be long, but the constitutional arguments for the states are strong. Then again, once it gets to the Supremes, we don't really know. Here, the state's counter theory is straightforward. Just to give some context and constitutional text, we talked about the election clause, and that gives election administration to the states. Congress may regulate it, but it chooses those limited tools and chose to enact NVRA. And Section 8 requires states to permit access to list maintenance records for inspection, not in photocopying. That is inspection of records, not compelled production of bulk databases. Those are real and meaningful differences. And beyond the statutory argument, the state privacy laws add on additional layer of protection that the DOJ is essentially asking courts to wholesale ignore. The broader constitutional point is that this is a classic federalism debate. The 10th Amendment reserves right to the states. The power is not delegated to the federal government, and the administration of election is the most historically state-controlled functions we have. When the executive branch now claims inherent authority to compel data transfers, that no statute explicitly requires, it's testing the limits of federal power, and precisely the way our constitutional structure was not designed to resist. It's not just an abstract theory, it's a tension at the heart of every case we've seen and that we're going to have discussed and we'll discuss today. I can't overemphasize the privacy implications here deserve special attention. Yeah, I think there's some real world stakes that become clear here. We were talking about the federal government building what amounts to a national voter database containing some of the most sensitive personal information Americans have: Social Security numbers, dates of birth, driver's license numbers, home addresses, and in many states, citizenship status and party affiliation. In Illinois, this is different. You don't actually register with a political party. In some states, you do. And so that's part of your voter registration is actual party, political party affiliation. And the federal government wants to create a giant comprehensive list of everyone in that form. The identity theft risk alone should get everyone pause too, especially when you aggregate that kind of data in one federal system. You do create a target. Data breaches happen. And unlike compromised credit card, you can't change your social security number or your date of birth. And the harm from the breach of this type of magnitude, if there were to happen, would be irreversible for many millions of Americans. Identity theft aside, we also have a political targeting risk when federal government can cross-reference voter rolls against immigration databases, criminal records, and other federal data sets. It gains the ability to flag and scrutinize individuals in ways that no legitimate law enforcement purpose, but that has no legitimate law enforcement purpose, but has the potential for intimidation and voter suppression. And that is why privacy harm the states are trying to prevent, and the existing federal privacy laws, including the Privacy Act and Driver's Privacy Protection Act, those were all designed to guard against, and those are being threatened right now. The separation of powers issue and concern is quite clean and is one that should resonate with every lawyer here. Article 1 gives Congress the authority to regulate federal elections under the Elections Clause. Congress exercised that authority with the NVRA and HAVA and other federal election statutes. The executive branch job is to enforce what Congress enacted, not to expand it by administrative demand. When the DOJ claims authority to compel states to produce records that no statute explicitly requires them to produce, it is not enforcing the law, it's writing new law by executive fiat. And that's Congress's job under Article 1. Critically, Congress has not enacted statute requiring any bulk handovers, as I noted. The SAVE Act that I'll talk about would change this calculus, but that's not law, and it doesn't appear to be making its way to actually being law, but one never knows. But until that were to ever happen, the executive has no statutory basis for what it's demanding. And this is major, perhaps underappreciated. Access to the voter data litigation is not just a federalism fight between states and the federal government, but it's also technically a separation of powers fight between the legislative and executive branches of Congress. It just happens to be that Congress is not asserting itself as strongly as one would hope or think here. And that skepticism should be applied here. Sorry. We do have the Department of Justice there has signed a number of confidential memoranda of understanding with certain states, and those are deeply troubling, and the details matter. These are mechanisms through which the DOJ has been acquiring this voter data from cooperating states. And when advocacy groups and journalists obtain copies of some of these agreements through FOIA and litigation, what they found was alarming on multiple levels. First, the security protocols in many of the MOUs were deemed inadequate for the sensitive type of data. We're talking about complete voter data files, as we talked about. And the MOUs often lack meaningful restrictions on who within the federal government can access that data, how long it can be retained, or for what purpose it can be used, beyond the stated list maintenance purpose mandate in the NAVRA. And second, and most damning, at least 15 states that have handed over complete voter files to the DOJ, and some did so without even requiring a confidentiality agreement, and they just transferred the data. And for the states that did insist on MOUs, the agreements they signed vary widely in their protections, which means there's no consistent federal standard on how this sensitive data is going to be handled. And this is precisely the kind of ad hoc, unaccountable data collection that federal privacy laws are supposed to prevent. And so each state has its own agreement or no agreement with the federal government. There's no limit on what the federal government can do with this data, or how it can use the data, or how it's supposed to store or protect the data. And that, on its face, is exceptionally alarming. The confidentiality around MOUs themselves add another layer of concern. I guess when the government demands data from you in secret and processes it in secret, there's no meaningful check on what it's actually doing. And so that's a governance problem, independent of what any legal authority is being discussed or litigated. Tying it specifically to Illinois, and what Illinois is doing, the Illinois State Board of Elections faced the exact same demand that went out to every other state: produce the complete unredacted voter file, including social security numbers and other sensitive personal identifiers. The board did the right thing. They refused, citing the Illinois Personal Information Protection Act and federal privacy statutes. And instead, they provided a publicly available version of the voter file, the same redacted data that Illinois law makes available to political parties and candidates in the election code. Anyone, if you have a committee, you can request this data and you can obtain it. It is publicly available, but it does not have, that list doesn't have some of the more sensitive data on. The DOJ, instead of accepting that, sued Illinois in December 2025 in the Central District, which is near Springfield. And the complaint alleges violations of Section 8 of the NVRA, claiming that Illinois improperly restricted access to list maintenance records. And Illinois has taken the position that is in full compliance with the NVRA's inspection provisions, and that the DOJ is conflating the right to inspect with a non-existent right to compel bulk data protection or production. Excuse me. What is particularly telling about the Illinois case is who else showed up. Labor unions and retiree organizations have sought to intervene as defendants and have been granted intervention rights. that tells you something about how important this threat is being perceived. When AFSCME and SEIU are showing up in a voter roll case, it is because their members understood that the data could be used against them. The intervener's brief argues that the voter file data their members submitted is being sought for purposes well beyond list maintenance, and they have standing to protect it. This will inevitably head up to the Seventh Circuit. I believe it's in the Seventh Circuit, and they'll weigh on the scope of the MVRA Section 8, and I'm sure it'll go beyond that if it's Illinois' case first or one that follows, or a different state's case. Now, why does it matter so much? Because we know intent shapes the legal analysis as well. So if the DOJ is pursuing voter roll data purely for MVRA list maintenance compliance, then at least there would be a colorable statutory argument. They could argue and say, well, we're actually doing it for these purposes. We're helping our agencies, etc. But if the real purpose was to really build this cross-referenced immigration enforcement database, the MVRA claim is pretext. And that is probably the most damning revelation in the entire litigation. There have been disclosed internal DOJ emails that show the real purpose, which is to cross-reference voter rolls against DHS SAVE database and find and remove suspected non-citizens. The DOJ, a DOJ attorney stated on the record in open court in Rhode Island, quote, "Our intention is to run this against DHS SAVE database." So the stated justification of list maintenance compliance was pretext. And former DOJ attorneys from the voting section itself have filed amicus briefs saying the agency has no statutory authority for this. So when career officials from the relevant divisions tell you that the agency is overstepping, I think that should carry at least a little significant amount of weight. And then historical context here, in 2017, the Presidential Advisory Commission on Election Integrity, chaired by then Kansas Secretary of State Chris Kobach, sent letters to 50 states demanding complete voter data rolls, including Social Security numbers, felony conviction records, etc. The response was almost universal resistance. More than 40 states refused in whole or in part. Courts enjoined the commission, and by January 2018, the commission was disbanded without ever even receiving any of the data it demanded. The legal question the commission raised remains the same question being litigated today, though. Can the executive branch compel disclosure of state voter data absent congressional mandate authorizing that disclosure? The answer in 2017 was effectively no. That answer should be the same today, but there are critical differences that make the current situation more dangerous than the commission's episode. First, and now it's the current DOJ. The first is the current DOJ is a presidentially appointed advisory commission. The DOJ is not a presidentially appointed advisory commission of questionable legal authority. It's the Department of Justice with actual litigating power and the ability to file federal lawsuits, which it has obviously done. Second, the current effort is backed by executive orders and coordinated across multiple federal agencies, including what was the DOJ and DHS, in ways the Kobach Commission never was. And third, and perhaps most importantly, Congress is now effectively considering legislation in the SAVE Act that would effectively ratify all of this executive action and what they're trying to do. That pending legislation changes the political and legal dynamics in which the Kobach Commission never faced, and the courts that rebuffed the commission did not have to confront those questions whether the imminent legislation would moot their rulings. From the history, then we have this root document that connects everything we've been discussing so far in this section. Executive Order 14248, signed on March 25th, 2025, is entitled Preserving and Protecting the Integrity of American Elections. It is a single executive action in which these voter data demands the DOJ law and demands and the DOJ lawsuits against the states, the SAVE database, cross-referencing, and the push to eliminate mail ballot grace periods. This is where this all originates. If we walk through the key provisions of this, Section 2A purports to require the Election Assistance Commission to mandate a documentary mandate documentary proof of citizenship on all federal voter registration forms. Only about half of Americans hold a passport, so this would have created a massive barrier to registration. Section 2B directed DHS and DOJ to create a cross-reference state voter rolls against the SAVE immigration database. This is where the DOJ's revealed purpose in the voter data litigation comes from. And Section 7 directed the DOJ to enforce a receipt by election day interpretation of federal law and threatened to withhold EAC grants from states that count late arriving vote by mail ballots. The court status is significant. Judge Kohler Coatley of the DC District Court permanently blocked multiple provisions in October 2025. She permanently enjoined Section 2A, the citizenship documentation requirement. In January 26th, she permanently blocked Sections 2D and 3D as well, declaring them inconsistent with constitutional separation of powers. The court found the president lacks authority unilaterally to alter election procedures. Challenge to remaining provisions, including the SAVE database, cross-referencing, and grant withholding threats, are ongoing. This is executive overreach framework in action. The president claiming his authority, the Constitution reserves to Congress and the states, and the courts pushing back. In April 2025, the preliminary injunction was denied as to Section 2B, and the SAVE database cross-referencing divisions have not been blocked. And so that's the critical distinction here, is that it presents the true purpose here, but those have not technically been blocked. Additionally, on March 31st, 2026, less than 2 months ago, the president signed a second election-related executive order, Executive Order 14399, the Ensuring Citizenship Verification and Integrity in Federal Elections order. It directs the creation of a federal list of adult citizens, a state citizenship list, requires the U.S. Postal Service to transmit mail ballots only to people on those lists, and ties federal election funding to state compliance. At least 5 legal challenges have already been filed. Election experts have called it most certainly unconstitutional, and it's also been assigned to the same judge, Kohler Coatley, who blocked most of the prior executive order, and she is hearing some of these new challenges. So it just continues on, but and really they're doing this to get it appealed to go to the Supreme Court. The legislative companion and component is the SAVE Act here, and where courts have blocked the executive order's citizenship documentation requirements as unconstitutional overreach, the SAVE Act is the response from Congress, and is trying to achieve that result through legislation. This is the statutory route that courts have blocked through executive order, or just pure executive action. So this is H.R. 22, which passed out of the House for the first time on April 10th, 2025, on strict party line votes, 220 to 208. This would amend the National Voter Registration Act to replace current attestation-based system where applicants swear to their citizenship under penalty of perjury with a strict documentary-based system requiring a passport, real ID compliant identification, or a birth certificate to be able to register or be to go to the polls. I don't know how many of you carry around your birth certificate, but think about that. There are 4 provisions every Illinois practitioner needs to know. First, the states would be prohibited from processing any federal voter registration without documentary citizenship proof. The bill creates a private right of action against election officials who register voters without verifying those documents, meaning county clerks could face civil lawsuits from private citizens. I'll leave it at that. Third, it mandates ongoing use of DHS SAVE database to verify citizenship of already registered voters, which is exactly what the DOJ's internal emails revealed they wanted to do with this voter data, proving the absolute pretext of the current litigation and the current efforts. And fourth, it imposes criminal penalties for election officials who fail to comply. The Senate received the bill on April 10th, and it had and also there. And then there's the revised Save America Act, which expanded HR 22 to include photo ID requirements for in-person and mail voting. It passed the House again on February 11th, 2026. This time by margin of 218 yes to 213 no. That version passed as an amendment to a Senate bill is what the Senate is currently considering right now. Debate began on that in March 17th, 2026. It's very unlikely that you'll get 60 votes to overcome a filibuster. Even if that bill has appeared to have stalled, the expanded Save America Act, which adds, again, the photo ID requirements for both in-person and mail voting, and signals where the legislative direction could keep going here. Especially after midterm elections. It depends on what happens, of course, but if Republicans retain both the Senate and the House, I would assume that these efforts would be renewed. Even practitioners in this room, every practitioner in this room should be tracking this because it would fundamentally change how voter registration works in Illinois, and every other state, of course. All right, so now we're going to turn to some national cases that will affect Illinois and one is actually out of Illinois as well. We turn to Bost and Watson. Then put Illinois' vote by mail framework directly in the crosshairs. And we'll also talk about the Purcell Doctrine, which adds critical timing dimension to all of this. And before we get into those details, I'll step back and explain why this section of the presentation matters so much, as it matters as much as some of this voter data litigation we just talked about. The voter data case is about executive overreach, the executive branch doing things that Congress never authorized. The Bost and Watson litigation is different. It shows the Supreme Court potentially reinterpreting federal election statutes in ways that would invalidate voting procedures that millions of Americans currently rely on or expect. And the Purcell Doctrine, which is a principle that courts should not change election rules too close to an election, determines whether any adverse ruling could take effect before November of 2026. And these aren't hypothetical threats. We have the oral argument transcripts from the Watson case, the RNC versus Watson case. We know what the questions, and you can listen to it online. It was pretty interesting, but we know what the questions are signaling and who may vote which way. In Illinois, we have one of the most voter-friendly mail ballot frameworks in the country. There's a 14-day grace period in terms of you have to cast your ballot by election day, but it can be received by the election authority 14 days after that. And we have intelligent mail barcode tracking as a backup for missing postmarks. We have same-day voter registration. And these are not accidents. It reflects decades of deliberate legislative choices in Illinois about how to maximize voter access while maintaining election integrity. Bost and Watson are cases that could unwind these choices, and I'm moving fast, and I don't see any legislative backup provisions, anything in the Illinois General Assembly right now, which is nearing the end of its session, to, so to speak, fight back against it. If anything has to change nationally, what is Illinois going to do to comply or otherwise change what it does? And there's really nothing in the hopper. It's not being contemplated at all. But Bost versus State Board of Elections is important for two distinct reasons, and we should understand both to appreciate where the law is really heading. First, there's the standing hold. The holding was based on standing in this case. The candidates have they held that the candidates had a concrete and particularized interest in the rules governing elections they are running in. The court held in a 7-2 decision that Mike Bost, who's a sitting congressman and ran in 2022, had standing to challenge Illinois' grace period in terms of the receiving and counting mail ballots because the rule that determines which ballots get counted in his race directly affects him. That's a broad and significant holding with implications well beyond mail ballot or even the election contest. It essentially opens the courthouse door to any candidate who wants to challenge an election rule that applies to their race. I would note that only 5 justices joined the Roberts majority. Justice Barrett concurred as well, joined by Justice Kagan on narrower grounds. They would have found that standing on a much more limited theory, that Barrett-Kagan coalition is interesting and worth watching in Watson that we'll discuss because it may signal how Barrett will approach the merits question as well. Second issue with Bost, and more importantly for Illinois, the court deliberately did not address the merits. After granting cert on the standing question, the majority resolved the issue and remanded it without reaching whether the Illinois grace period is consistent with federal law. The practical effect is that Illinois grace period counting remains in place for now, but the constitutional statutory questions that could invalidate it are preserved and heading to Watson, where the merits clock is being discussed. I pay close attention to what Bost did not decide, unless it really did leave a list of open questions that are important, as important as the holding itself. The court did not say whether grace periods are legal under federal law. It did not say whether election day means the deadline for casting your ballot as defined in federal law, or whether it's for its receipt by election officials. It did not say whether Congress's establishment of a uniform federal election day preempts state flexibility to count late arriving ballots. Those 3 questions are merits questions, and none of them were answered at all. And that matters enormously because the current Illinois 14-day grace period window for counting late arriving vote by mail ballots is valid as a matter of state law and unresolved as a matter of federal law. And any election cycle between now and when Watson is ultimately decided on the merits could be conducted under that type of cloud of uncertainty. We have, and if the court in Watson hold that federal law requires receipt by election day, receipt and counting and everything must be in by election day, the question of retroactive application, what happens to ballots cast under old rules before the court ruled, is still an open question as well. The lower court path also matters. Bost was remanded to the 7th Circuit, which means Illinois will be one of the circuits wrestling with the merits questions on remand. And they had affirmed the dismissal. So we're waiting to see what's going to happen, or if it will be mooted by the Watson decision, or what will happen there. As an aside, the Illinois specific statutes provided some reference. It's under section 19-8 of the election code. It's the provision that establishes the 14-day grace period for mail ballot. Again, it's not that you can mail it anytime in that 14-day. It must be postmarked, mailed, put in the mailbox by election day. It's that the election authority, the county clerk, Chicago Board of Election Commissioners, etc., can receive that mail within 14 days. And there are other ways for the election authority to determine when it was mailed, if there is no postmark on it. And to put it in perspective, in 2024, over 18% of Illinois voters cast mail ballots. That during the pandemic in 2020 was nearly a third of all voters did that. And we're not talking about a niche voting method used by a handful of snowbirds. We've hundreds of thousands of Illinoisans who would be disproportionately affected here if these rules were to change suddenly. And that's very much may happen as we talk about Watson versus the RNC, which is where this merits question may be answered. And the core legal question here is deceptively simple. Does election day mean the deadline for casting your ballot, or its receipt, or both? At oral argument on March 23rd, the lines were fairly predictable but illuminating. Paul Clement was actually arguing for the Libertarian Party of Mississippi, not the RNC, but he pushed for a strict receipt interpretation. And the Trump administration threw back these challengers. Mississippi's own Solicitor General actually argued against the RNC's position, defending the state authority to set its own procedures, which is interesting. Over on the bench, you had Gorsuch, Alito, and Thomas. They were clearly skeptical of grace periods for counting ballots. Kagan, Sotomayor, and Jackson mounted strong defense of state authority and practical realities of mail voting and asked those questions accordingly. The swing votes to watch now are Roberts and Barrett, both of whom asked pointed questions about downstream effects on early voting and absentee systems. And to note, roughly 30 states have some form of grace period. So the impact could be far beyond that of Mississippi. If the courts side with challengers, the 14-day period for counting ballots would almost certainly be gone, at least as to federal ballots. There's a difference between how it would affect state races or local races. This would be for federal offices. And so how a county clerk or whomever would be able to distinguish or differentiate and how to deal with that is another whole aspect to this. And the decision on Watson from the Supreme Court is expected perhaps in late June or early July. So right before, only a little bit before the midterm November elections. And the practical impact can't be overstated. This would disproportionately affect rural, elderly, minority communities, and everyone who relies on mail voting. It's the most consequential election law cases in a generation. And one important nuance to flag is a ruling against grace periods in Watson would almost certainly apply to federal elections, congressional and presidential races, not necessarily the state or local ones. So like I was just saying, Illinois could still count late arriving mail ballots for state, legislative, judicial, and local races under its own rules. But that would also create huge amount of administrative complexity for county clerks who would need to be able to somehow sort these out, and also potential cause of the confusion risk for voters and otherwise is a serious concern. So what also is in play here is what we call the Purcell Doctrine. And we're going to walk through this to kind of set the stage of how this is changing, because we're getting really close to an election. You would expect the Supreme Court to stay out of it, because this is from a rule in 2006. Purcell versus Gonzalez is a per curiam opinion, not even a full merits decision. The court vacated a Ninth Circuit injunction that had blocked Arizona voter ID laws that were imposed weeks before the 2006 election. The rationale was modest and procedural. A last-minute court orders changing election rules risk voter confusion and undermine the orderly administration of election. The doctrine was symmetrical on its face. It applied equally to changes expanding or restricting the rules. And it was understood that this was a timings principle. This is not a merit screen. Basically, the courts could still evaluate the underlying claims. They just shouldn't issue injunctive relief so close to an election. You can't change the rules by court order right before the election. And this doctrine has been shifting. First by scope. The original Purcell applied to federal court injunctions that changed status quo. The court expanded it to cover state court rulings, interpreting state law, and even state legislative changes in RNC versus Wetzel, which was where there was a suit to block the Pennsylvania state court ruling on a mail ballot requirement under state law. And the court, this was a dramatic expansion of federal timing doctrine being used to override a state court interpretation of its own constitution. Second, now we're seeing some asymmetry, though, and this is a critical shift. For example, in Merrill versus Milligan in 2022, the court stayed in Voting Rights Act Section 2 injunction requiring Alabama to create an additional majority Black congressional district. That stay came weeks before the primary, and the effect was to preserve the challenge map, the one the lower court had found discriminatory. But the Supreme Court has not applied the same scrutiny to restrictive changes close to elections. States have been permitted to tighten voter ID requirements, purge voter rolls, and close polling locations in weeks before elections without Purcell intervention. So the pattern has become a little bit clearer that expansive changes get frozen, but restrictive changes proceed. And Justice Kagan flagged this asymmetry in the Merrill dissent, noting the doctrine was being wielded as a one-way ratchet against voting rights. Third, there's some merits creep in Purcell. It's supposed to be about timing, and now it's becoming more about substance. And when you stay in injunction requiring a VRA compliant map, you're signaling that the VRA claim is unlikely to succeed. Otherwise, the equities would favor the injunction, of course. So, and this is this whole shadow docket system of the Supreme Court, and how things are basically getting decided de facto merits rulings without formal briefing, oral argument, or full written opinions. That's a significant due process concern and leaves lower courts guessing about what actually to do. For Watson, if the court rules against Illinois' grace period, or the grace periods in general, the Purcell should, in theory, prevent implementation before the 2026 midterms, but it's also very likely that it won't. And moving also on to, in line with the talking about mail, we also had changes to the USPS postmark system, and I know I'm running long, so I will try to speed along. Basically, the USPS changed how it applies postmarks, and those changes interact with pending Supreme Court litigation in ways that now narrow how vote-by-mail ballots can be considered valid. And think of it this way: if the court in Watson eliminates grace periods for federal elections, then the postmark only becomes the only thing standing between the timely ballot and the rejected one. The voter's legal protection collapses in a single data point, the postmark date. The USPS, through its own operational restructuring, has made postmarks significantly less reliable. So basically, what happened with the changes that postmarks were usually done at more locations, and now it's been changed so that they're only going to be at the regional distribution centers instead of local processing facilities. So if a letter is dropped in the mailbox on a Tuesday, it may not receive an actual postmark until it reaches the regional hub, maybe 2 or 3 days later. Whereas under the old system, it would have been postmarked on that day at the day of pickup. So that could be the difference in in this world of when things are deemed, mailed, and if it's a valid or invalid ballot. And it goes into counter to what we as lawyers take as the mailbox rule principle. When you put something in the mail, it's deemed that's when you send it, right? Well, if you can't verify that, if the mailbox rule, if you're getting postmarks 2 or 3 days after being dropped in the mail, there's no verification anymore. There's nothing to show when it was actually mailed. And it's really under attack by the current litigation and these USPS changes. And how it really this was in place for the Illinois primary, and it was a signal. A lot of county clerks were making sure to inform the electorate with a lot of guidance, but it takes a huge amount of voter education to help correct some of these, because people are used to just being able to drop their ballot in on election day, and you really can't do that anymore. If you do that, you're risking your ballot being invalidated, because it will show that even with the grace period counting, the postmark would show that it was not mailed. It would not prove that it was mailed on election day. It would show the being postmarked days after. I'm going to fly through this. There's the threats of federal enforcement at polling locations. Basically, this is explicitly against federal law, but they are the federal government has been threatening it. There's a huge threat that this may happen, or that immigration enforcement and customs enforcement would be out and about on election day, at least to not even for actual enforcement actions, but for pure intimidation purposes. And it's a serious concern. Illinois does have its own protection for election workers codified in law. But again, we're talking state law versus federal law and federal law enforcement, and that often gets jammed up. I do want to get to and talk about the more recent decision, Louisiana versus CLE, and the Voting Rights Act, which has essentially been dismantled. We have the kind of a we have the holding, and what the holding essentially did was to reframe what we call the jingles factors, and put what the old factors were and what the new requirements are. Since Thornburg versus Jingles in 1986, we had a three-part precondition test as a gateway for Section 2 vote dilution claims under the Voting Rights Act. And basically, if you could show compactness, cohesion, and white voting bloc, you had a viable claim. And it was a totality of the circumstances analysis. And this was statute Senate factors, and looking at the history of discrimination on jurisdiction, in the jurisdiction, ongoing effects, and whether the political process was equally open. This was an effects test. Congress passed the 1982 amendment and specifically overruled Mobile versus Bolden's intent requirement. So you didn't need to prove the legislator drew the map with a discriminatory purpose. It was, does it have a discriminatory effect? Now we walk through the three changes that the most recent case made. First, illustrative maps. Under the old framework, plaintiffs had to show a compact majority-minority district could have been drawn. That was Jingles prong 1. Under CLE, the illustrative map must now satisfy all of the jurisdiction's legitimate political objectives, including incumbent protection and communities of interest. As a dramatically higher bar, because the state gets to define the objectives the plaintiffs must meet. So in order to present a challengeable map and say, oh, you could have drawn this better district under the Voting Rights Act, it has to admit, it's not just that you could have drawn a majority-minority district. It's you could have drawn a majority-minority district and protected the incumbent and protected this community of interest and done all of this that the state also gets to define. The other change is the racial block voting requirement. The Jingles prong 3 asks whether white voters voted sufficiently as a block, basically to defeat minority preferred candidates. And that's a statistical analysis that was required under the Jingles factor. CLE now requires plaintiffs prove that this racial block voting cannot be explained by partisan affiliation. And this is where there's a case from 2019, Rucho versus Common Cause. It really becomes devastating, where the court held that partisan gerrymandering claims are non-justiciable. And federal courts can't hear partisan gerrymandering claims. So now the state can say, well, we drew these maps for partisan reasons, and courts apparently can't question that, and plaintiffs can't prove racial voting block is independent of partisanship. And the catch-22 here is nearly airtight. I mean, that is the gutting issue. And third, the totality of circumstances. The old framework gives a significant weight to historical discrimination and ongoing effects, the legacy of Jim Crow, decades of discrimination, discriminatory voting practices, socioeconomic disparities linked to historical exclusion. CLE requires strong evidence of present-day intentional racial discrimination regarding voting. The past discrimination and what courts calls ongoing effects of societal discrimination are entitled to, quote, much less weight. In states where the most overt discrimination happened decades ago, which is most of the jurisdictions Section 2 is designed to protect against, this requirement is essentially impossible to meet. Justice Kagan's dissent from the bottom line frames the bottom line. The majority has completed the demolition of the VRA. Section 2 remains on the books but the evidentiary requirements are now so high that successful vote dilution claims may be functionally impossible. As Stanford's Pamela Carlin put it, it is unclear there is a single case you should now bring under Section 2 that you could not also bring directly under the 14th Amendment, making Section 2 redundant at best. This is the doctrinal shift driving everything on the next slide in the redistricting aftermath. Because as the practical consequences of the post-CLE redistricting wave are still unfolding, and they illustrate the second arm of the dual pressure in real time that we talked about before. When a Supreme Court decision triggers this kind of immediate nationwide legislative activity, it tells you something important. States were waiting for this permission. And the aftermath has been swift. At least 8 states have enacted maps within days of the ruling. Louisiana suspended its May 16th primaries after more than 100,000 early votes had already been cast. A massive disenfranchisement of voters whose ballots were cast under maps that are now gone. Louisiana's postponement of May 16 primaries is itself being challenged in court, and voters have filed suit in both federal and state court, and the Supreme Court has agreed to expedite the remand proceedings. The primaries were rescheduled for July 15th, pending resolution of those challenges, and the courts may reinstate the original map or original election date, but it is too early to tell. Alabama presents a related but distinct situation. Rather than delay its primaries, Alabama attempted to revert to a 2023 map that had already been found unconstitutional. A federal district court blocked that move today, May 26th. The case is heading to the Supreme Court immediately, which means the justices who decide the CLE will have to immediately confront how their decision applies to maps that have already been found discriminatory. And that's a significant development to watch. And we'll see how that goes. That Tennessee has called a special session beginning May 5th to redraw its congressional lines. And again, these are not, it just as another example, these are not abstract legal developments. They're elections being restructured in real time, often with very little public notice. Both parties are pursuing, seems maximalist strategies. The practical effect is a significant Republican advantage in the first wave of redraws, though Democrats are trying to respond in state control. State courts now are likely to be the primary battleground for these redistricting challenges, since the Supreme Court has removed much of the federal floor that was there. And we saw that in Virginia with the state Supreme Court rejecting that state's redistricting efforts. In the states with independent redistricting commissions or state constitutional protections against partisan gerrymandering may offer the strongest remaining constraints on any of this activity. And that the 2026 midterms will be the first major real test of this new landscape and how it all plays out. I made this practitioner guide of what to do or how to react, and what we can do moving forward. But really, I want to bring this back to where we started. I know it's running late, and thank you for bearing with me. Basically, the core thesis of the presentation is state authority over elections is under an unprecedented dual assault. With the executive branch reaching for power the Constitution never gave it, demanding voter data, claiming supervisory authority, testing the limits of federal enforcement. And then we have the Supreme Court is simultaneously pulling away for federal protections that have constrained both state and federal governments for decades. CLE just gutted the Voting Rights Act redistricting protections. Watson may eliminate vote-by-mail grace periods in 30 states or more. And on the legislative side, we've talked about the Save America Act, an expanded version that both have passed the House of Representatives, that would impose documentary proof of citizenship requirements for federal voter registration, along with the executive orders that have attempted to extend those requirements and just implement them through executive action alone. These all represent a coordinated effort to reshape who can vote, how they vote, and which districts they can count in, which districts their votes can count in. The states are caught in the middle and squeezed from every side. But here's the point. part, I refuse to end on a pessimistic note, too pessimistic, I guess. The reason this room full of lawyers is matters is that the legal profession is genuinely the last institutional check on what is happening. Every one of the developments I discussed today, voter data fights, SAVE Act litigation, grace period cases, redistricting, those are going to be decided in courtrooms. And we need lawyers, we need election protection organizations and volunteers to be on the ground and advocating in state legislators to pushing for voter access protections and pushing against some of these federal oversteps. And then voters need education about their rights and options before rules change out from under them. Lawyers are the ones that can actually explain some of this stuff to lay persons if we try hard enough. And in pending litigation, when you join organizations that need amicus participation, intervention, direct representation, it's not just a moment for hand wringing. It's a moment really for lawyering. And if lawyers don't step up, then no one will. And the constitutional framework that allocates election authority exists precisely to be defending, and defending is what lawyers do. So I thank you for bearing with me today. Happy to take any questions. Again, I have a disclaimer. Nothing here in this intended as legal advice. Happy to answer any questions that you may have.
Thank you, Russ. I didn't see any in the chat, but if people want to put them in now, or if you want to raise your hand, or if you just want to mute yourself. But while we're waiting for that, I have lots of questions, but one that just puzzles me out of this whole mess. Yesterday I was reading, I don't remember what state it is, that they postponed their already scheduled elections, but only for some congressional districts, and they're having them for the others. And I can't understand how that would work, because some of the people who vote will inevitably wind up being in the other, will be in another district. So what happens with that?
Yeah, and that's all.
Excuse me, by the way, I am putting up the poll for those people who need to sign off, but go ahead, us.
It's like in Louisiana, it's probably subject to some sort of litigation. I don't know how it will actually pan out and work. In Illinois, that would be nearly impossible. And that's where any talk in Illinois of now redistricting, now that we've had a primary, would be it's not going to happen for the 2026 elections. Given that we have people who are nominated for various parties at elections, we have now, today is the last day for independents or new parties to file for the November election in Illinois. And so in practical terms, it's impossible. But in other states, how they're trying to concoct ways to do that, I don't know how they would do it legally or constitutionally, but I guess that would be, we'll have to see how it pans out and what courts say, or if the Supreme Court, as I was saying, with the Purcell principle, I wouldn't be surprised if now the Supreme Court says, well, you can't challenge the state changing its rules because it's too close to the election, which would be just ironic and ridiculous. But
sounds like it's going to be a huge legal mess afterwards.
And you can see where that's kind of the point, right?
Yeah. Well, I suppose. Because I'm also thinking in terms of how long it takes the, election authorities. I mean, they would have to recode everyone in all the voters in the database for the right districts, and then put all that information encoded into the machines and on the paper ballots where they use paper ballots. And I just don't see how that works.
It would be, and the amount of people that would have the wrong information there would be some, because it happens here. People, are coded in the wrong district or wrong for whatever, and it's just error. I do know that, for example, in Illinois, if the Supreme Court rules that you cannot count federal elections after the date of the election, there are at least two election jurisdictions, Cook County and City of Chicago, which are separate, that have the technology to be able to separate out the counting so that if your ballot is received after election day, your votes for state and local offices could be counted, but your federal votes would just not. So it depends on the machines and the technology to be able to do that and to implement it, and state law that would allow it, or Supreme Court order that would require it. But
No, hold on.
that technology exists. Whether that exists in every county and every other election authority in the state, I don't, is unlikely. But it does exist. I know the election, at least Cook County and Chicago, are very astute and aware of monitoring it significantly. But that's one of the more concerning ones to see, because it might change the rules very quickly from us, especially in Illinois specific stuff.
Well, thank you. I mean, I could ask you questions for another hour, but people need to go, and I don't see anyone else with questions. So I just want to thank you again for this excellent presentation. This was very, very informative, and I appreciate your call for attorneys to step up to that this is up to the legal profession to kind of defend against all of this overreaching. So thank you very much. I'm going to stop recording.